Hello, all you civics students out there. I am Caroline. Today we are doing you a major favor. Of course, we know you would never do anything wrong, at least on purpose. You are a good, upstanding citizen who always follows the law. However, even the best citizens can sometimes find themselves on the other side of the law. If that is ever the case for you, you better know your rights. At the end of today's lesson, you will be able to explain the process in a criminal case. Before we get started, I want to issue another disclaimer. In this lesson, we will walk you through a general process in a criminal case. However, each jurisdiction can be different depending on the state and local laws, specific nature of the crime, and administrative rules that guide the police and prosecutors. For a look into your local jurisdiction, open up the PDF and complete the activities. Come along! Up until this point, throughout this series, we have covered almost all aspects of the judicial branch except for its processes. Consider this phrase, due process of law. The 14th Amendment says no state can refuse a U.S. citizen due process of law. This means that, from start to finish, the legal system must adhere to a strict process that begins with an investigation and may end in a trial. Remember, much of this process is detailed in the Bill of Rights, known as legal rights. Aside from these enumerated rights, the process has been developed by a mix of common law and statutory law. Word alert! Common law refers to law developed through judicial decision, precedent. Statutory law refers to law passed by legislatures. Let's walk you through the process just so you can be aware of your rights. The criminal case process begins when the police investigate a crime and find suspects. Then the process of gathering evidence begins, and there is a strict procedure for this. First, the investigating team needs to establish something called probable cause. This means that police must show reasonable suspicion based on facts to obtain warrants from a judge in order to gather evidence. The Fourth Amendment details this process. The point of this procedure is to make sure people feel safe in their homes, in their work, in their activities, and just generally as private citizens. Privacy, and the right to it, is important. So let's say they obtain the warrant they're looking for. They've established that probable cause. You may be picked up for interrogation at this point. The good news is, if the police question you, you do not have to answer their questions. The Fifth Amendment guarantees this. It is the right to remain silent. The other important right to remember here is your Sixth Amendment right to an attorney. According to the Sixth Amendment, you can at any point request a lawyer. Finally, imagine sitting in an interrogation room for days with the agents conducting their investigation hoping you will crack. Nope. Detaining you indefinitely is illegal, my friends. Phew. Uh-oh. Things don't go right. You were caught in a lie. They have great evidence against you. The police decide they want to arrest and charge you, but wait. The Fourth Amendment requires an arrest warrant. So first, the police must file an affidavit with the court. First, the district attorney reviews the affidavit to determine if the case is strong enough to present to a grand jury or judge in order to obtain an arrest warrant. Triple word alert! An affidavit is a document the police must complete under oath which details the nature of the crime and evidence. A district attorney is an elected official that leads a local prosecutor's office. A grand jury is a body of peers that reviews evidence and determines if an indictment will be issued. A grand jury or judge typically reviews the affidavit and recommends whether to indict the person. Many jurisdictions, the prosecutor has a large say in whether to indict. If the person is indicted, a judge issues an arrest warrant. In your case, just for the sake of our lesson, he does. At the point of arrest, the indictment is issued and the defendant is informed of their rights. Not great news for you, buddy. Word alert! An indictment is an official court document that charges a person for a crime and initiates an arraignment. Arraignment is the next step in the process. Now, you must show up for your arraignment. The Sixth Amendment requires a speedy trial. Writ of habeas corpus requires you to be brought before a judge to hear the charges against you, a process known as arraignment. At this point, you enter an initial plea and bail may be set. For felonies, if you plead not guilty, a jury becomes a requirement. Side note here, many misdemeanors or trials in which the penalty is less than 6 months or a small fine may not require a jury. Before entering a plea, the district attorney's office may offer you a plea bargain. A guilty plea during arraignment will take you to a judge for sentencing. Once the charges have been officially filed by the DA's office, the person comes back in front of a judge. So, to recap indictment and the arraignment process, after a person has been indicted, meaning charged, and arrested, the person may be offered a plea bargain, enters the plea, and bail is reviewed. Word alert! A plea bargain is a deal offered by the DA's office to a suspect in order to avoid trial. A plea bargain is usually an offer of a lesser charge that decreases sentencing. In many cases, the defendant will take a plea bargain to avoid losing at trial. But you don't. Nope. You know you didn't do it, and you would never claim to be guilty when you have the truth on your side. You're innocent. So, we're going to trial. In a trial, the prosecutor acts as the plaintiff in criminal cases. The prosecution gets to present their case first and must meet the burden of proof, which in criminal cases is beyond a reasonable doubt. During the prosecution's case, the defense is entitled to cross-examine witnesses and evidence in order to create reasonable doubt. After the prosecution presents their case, the defense is entitled to present witnesses and evidence that cast doubt on the prosecution's case. The prosecution can cross-examine the defense witnesses. Once both sides present their cases and closing arguments are made, the jury deliberates on the case and returns a verdict. A verdict must be unanimous, or else it's a hung jury and the case is declared a mistrial and kicked out, but it can be prosecuted again. The verdict is either guilty or not guilty, and the jury that decides this is made up of 12 people. If a guilty verdict comes back, we have sentencing. It's the judge, not the jury, that issues sentencing if a guilty verdict is found, except in cases where the death penalty is being sought. Now, even if you are convicted, defendants do have the right to file appeals if they feel due process or legal rights were violated at any step in the process. Appeals go to a state's court of appeals, and then typically go to the state Supreme Court. Just be aware, these courts can refuse to hear cases, and if they do, you do not always have the same legal protections. So, that's how it works if you commit a crime, but you won't, so no need to go any further, right? But there are also other kinds of cases called civil cases. Check out the PDF for a cool activity on suing your favorite burger joint. Time for a Show What You Know! First, create a flowchart like the one used throughout the video to detail the process of a criminal case. Next, answer a couple of extra questions to show what you know. What type of rights inform the legal process? In your opinion, what steps are key in ensuring justice prevails? Recap! The Bill of Rights establishes a number of legal rights that serve as the foundation for this process. There is a particular process for both criminal cases that include jury trials and the possibility to appeal a verdict. In our next lesson, we will analyze the local government in terms of its structure and selection of officials. But that, my friends, is for another day. Have a wonderful rest of your day, and as always, remember to vote, debate, and participate.
Hey, hey.